How does a joint with right of survivorship deed work in Florida? What is the benefit of this type of deed? There's actually several different ways a person can own real property in Florida. And I'm glad this question got asked because I will often see this with my clients that they sign a deed that has certain wording on it, they didn't know what it meant, or certain wording isn't on it that they would have wanted to be on it. So what ends up happening is that the deed for the real property that they sign, and the deed is what shows the ownership of the property. But what can happen is what they signed isn't what they intended it to be, right? Because again, the deed, depending on what words it has or what words it doesn't have, it's going to affect the type of ownership involved. And if you don't have an understanding of this, you can very easily sign a deed that is written in a way so that the ownership isn't what you wanted and you're stuck with that deed, especially once it's been signed by all parties and recorded. Now, sometimes it can be changed. In certain instances, you need everyone to agree, but it's just best to do it right from the beginning. That way you're not paying extra fees to fix a mistake. All right, so this type of deed that the person's asking about in the comments, it's actually Joint Tenants with Rights of Survivorship is the name of the deed. And you need to think about it much like, say, a joint bank account would operate, in the sense that if it's owned jointly, we see this a lot with spouses, right? Well, they'll have a joint checking account and a joint savings account potentially. So what happens is when one spouse passes away, on a joint account, the other spouse owns the account 100%. And this would be the same even if it's not spouses. If you go and, say I open up a bank account with my mom and we own it jointly, same thing would happen. If I pass away, rather than that account going to my husband, if I owned it jointly with my mom's automatically the owner. The idea behind this is that each individual actually owns 100% of the asset rather than them owning a portion of the asset. So that's why when one passes away, it's automatically fully owned by the other. So the joint tenants with rights of survivorship on a deed functions the same way. So what this means is when you're buying property, or even when you're transferring property in a way that you're redoing a deed, if you list 2 or more people on it and say that these people are joint tenants with rights of survivorship, what you're actually saying is each one of them owns the whole. So a couple things. One, if you're going to be selling the property, everyone would have to agree and everyone would have to sign off on it. The other thing, which is why people usually like to do joint tenants with rights of survivorship deeds, or at least this is what I've seen in my practice, is when one of the owners passes away, the other owners just automatically own the property without a need for probate. Again, just like the joint account. If you have a joint bank account, automatically goes to the joint owner, no probate's necessary. So it's the same on a deed that says joint tenants with rights of survivorship. Let's say you have 3 owners, they're joint tenants with rights of survivorship. One of the owners dies, the other 2 are going to own the property. Then when another owner dies, the last person standing owns the property. Now, obviously, once the last person standing dies, then we have the issue of probate. So this isn't perfect from an estate planning perspective, because you will eventually get to a point where probate is needed, but it does at least avoid probate at 1 or more stages, depending on how many owners there are for the property. Again, the biggest issue that could pop up, which I brought up when I first started talking about these deeds, is you do need everyone's permission for everything. You're all joint owners. You're in it together, so you can't just sell the property, without everyone agreeing to that. If you did something like that, you would create a bunch of problems. So that's a real estate question for another video. We're not going to get into that in this video, but mainly you want to make sure that if you do have joint tenancy property, joint tenants with rights of survivorship, that everyone is sort of in it together. If you're going to sell, you're all going to agree to sell. That makes things much easier. And again, it does make it better for succession planning, meaning if you maybe own property with a parent, when they die, the property would automatically be yours without a probate. So if you don't write joint tenants with rights of survivorship on the deed, or you don't make it clear that the owners are joint tenants with rights of survivorship, they actually become what's called tenants in common. So this would be the case if you are just listing individuals' names and saying, hey, Betsy owns this property with Fred, and you're just listing them as individuals. So if you just list Betsy and Fred as individuals, then rather than having any kind of rights of survivorship, Betsy and Fred each own 50%. Right? So you have 50% for Betsy, 50% for Fred. So what happens in this scenario is that if Betsy passes away, her 50% would be subject to a probate proceeding for her estate. And if Fred passes away, his 50% has to go through probate in his estate. So a lot of times I will see these deeds that don't say joint tenants with rights of survivorship, and the owners did not know that that is what that means. So if you just see individuals' names, it's going to be split between those individuals. They're each going to own an undivided share in the property, whatever that share is. I used in my example 2 people to show a 50-50 split. But essentially what that means is 50% of the property has to go through one person's estate when they die, and the other 50% has to go through another person's estate when they die. So if this is the scenario, we'll often suggest that people get ladybird deeds for each of their 50%, so they can pass down their ownership without it going through probate. So there are different reasons that someone might want to just own a percentage of the property and not be involved in a deed that is a joint tenants deed. So this is obviously something that you should discuss with an attorney, because you should weigh the pros and cons, and obviously the deed should be geared towards what goals you are trying to accomplish. But the biggest benefit, and to answer the second part of this question here, is when someone passes away, when the deed says joint tenants with rights of survivorship, when someone passes away, the property is just automatically owned by the surviving owners, and you don't have to go through a probate process. So that's what I've seen in my practice as the biggest benefit. All right, I hope this answers the question. If you have any other questions about deeds or ways to avoid probate and you're in Florida, don't hesitate to contact us. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.